All right, good morning again. Next case on the docket, 23821, O'Day versus O'Day as personal representative. Again, 20 minutes per side. Appellant can reserve as much of that as you would like for rebuttal. I'll set it at 5 minutes unless you would like something other than that. And when you are ready, you may proceed.
Thank you. Good morning. May it please the court. My name is Kelly Feig. I represent the appellant, Hannah Alcor, previously Hannah O'Day. And before I begin, I just want to let the court know that this is, although I've been a member of the bar since 2007, this is the first time I've had an opportunity to make oral arguments. So
in front of us?
A little excited. No, at all.
Oh, at all.
Ever.
Okay. Well, good luck.
Thank you. Ms. Alcor comes before the court this morning seeking a reversal of an order from the trial court that denied her petition to remove the personal representative. The court has jurisdiction under 9.170B, subsection 6.
Because the PR is a fiduciary.
Correct.
Okay.
And the standard of review on removing a personal representative, since it's a discretionary decision of the trial court, is an abuse of discretion, except where the court relies incorrectly on law, it would be a de novo review. And what I would like to focus my time on today is the second argument in my initial brief, which was that the trial court's failure to remove the personal representative was an abuse of discretion.
So there's two assets in the estate that you're claiming. One is this settlement, is that correct? That's one of the assets,
correct.
And then the other is whatever interest might be in the JS Land Trust, correct?
Correct.
Okay, and the trial court ruled that the JS Land Trust is not part of the estate, correct?
Correct.
So other than those two assets, what else is there to administer?
I don't understand your question. Are you asking how much further in the estate?
What else is there to do? What point would there be for, my understanding is that from the record below that the amount that is owed to your client is sitting in a restricted account. And so what point, I guess this is what I understood the trial court to say is, what would be the reason for removing the personal representative at this point? What else is there left to do?
Thank you, Your Honor. So what is left to do, there's multiple parts that I want to address in what you said, but first I will answer. What there's left to do, from my understanding, is basically approve the final accounting, and you would be finished with the administration of the estate. Going back to the JS Land Trust issue, that was brought up by my opponent in the trial court at trial, where they first announced that the decedent has no interest in the JS Land Trust. However, in the appellee's initial verified answer, he admits it. It's number 3 on his verified answer. There is an amended verified answer where he still admits it, also number 3. And there are sworn answers to admissions, a request for admission, his sworn answers and his amended sworn answers.
So is your sole reason for saying that I think it would be 1/3 interest of the JS Land Trust as part of the estate is based on his representation in the inventory and in the answers?
In the 3 inventories, the answers and the
so I think below
admission.
I think below you said, you stated it's by implication.
Correct.
That's what you said, by implication. So that's your sole reason for believing that the estate is entitled to, or that's your position that the estate is entitled to 1/3 interest. Is that what you were arguing?
No, it has never been an issue. It was never a contested issue that the 1/3 interest in the JS Land Trust belonged to the estate. And one of the issues that I raised in my brief, which is judicial estoppel, because my opponent in the family case in August, just a few months prior, argued that the JS Land Trust is not a marital asset, but it is a probate asset. And the appellee also testified at the divorce trial that the JS Land Trust is, and I can give you the page in the, I think it's 38 of my initial brief. But he also testified at the divorce that it was part of the probate, and the judge in the divorce case agreed, and they won on that issue. And 3 months later, they're coming into the probate court for the first time in 3.5 years to assert that it's a marital asset and not a probate asset.
So what was, I mean, in the land trust, the JS Land Trust, there was a piece of property in Tampa, right?
There were 2 properties.
That was sold,
Judge
and
Lambert.
wasn't that put into the party's joint account, the proceeds?
So there's no evidence or testimony that states that it was put into the party's joint account. There is a copy of the check from the trustee at the time, Jawad Saima, who received a check from selling the Tampa property, and the only person that signs off on that check is the appellee, Mr. Odeh, and there's no evidence that was presented except for Mr. Odeh's testimony that he put it in the joint account, but they did not present any evidence. My client, of course, also testified below and stated that it did not go in the joint account.
The Leesburg property that Judge Lambert referenced, that's been sold, correct?
That has also been sold, but the estate asset regarding that property, what we're asserting, is the mortgage on that, and that Mr. Odeh, when he sold the property, sold it at a 0% mortgage encumbering that land trust. The only beneficiary of the land trust.
Did you ask below, though, to void that sale? I believe below in your pleadings, you asked to void the sale to the to the Leesburg property?
Correct, at the time, that's what we had pled.
Okay, but you would have, did you notify the party that was actually purchased the they would have had to been noticed, correct?
Correct.
Okay.
Correct, Judge Boatwright. And I had many conversations with the attorney that was representing the buyer, and
Well, who's the mortgagee on that sale regarding that? Who gets the monthly payment?
So the land trust is supposed to get the monthly payments, the beneficiary of the land trust, but it goes directly via Zelle into Mr. Odeh's personal account. There were hearings below regarding the money, since everybody was on the same page that the estate had a 1/3 interest in that mortgage. And it was represented by Mr. Odeh's first counsel, Mr. Urchin, that the money was going into the estate account, which wasn't true at the time. And so he began depositing money, but then stopped.
Well, let me ask, what we're here about today is you're saying that the trial court reversibly erred by not removing Mr. Odeh?
Yes.
By not removing him as the PR. And part of that is because he's not administering the estate the way you believe he should be administering under the statute. But if the trial judge finds that the JS Land Trust is not an asset of the estate, then by definition, he's not maladministering the estate vis-a-vis that property, right?
As to the mortgage, but he still maladministered the estate, Judge Lambert.
But what I'm asking is, like following what Judge Boatwright asked earlier, the assets of the estate are the settlement regarding their adult son.
It's in cash now, yes.
It's who?
It's in cash. The settlement came through.
Right.
So it's the proceeds, yes.
There's money to be distributed. So that's an asset. And the other asset is this JS Land Trust, interest in the JS Land Trust.
It's as placed on the inventory, the 3 inventories, it's an interest in the one-third interest in the mortgage coming in to the beneficiary of the JS Land Trust. The only entity that's no longer a valid corporation or a limited liability company that was the beneficiary of that land trust was AMA Management, AMA Investment Management LLC. That's the only beneficiary of the land trust and was always the only beneficiary of the land trust. And that corporation had 3 officers.
And that corporation is dissolved now, correct?
Correct. It dissolved 1 year later.
1 year after the death of their son, right? Or no?
Correct.
Okay. So that's the beneficiary of the trust.
Correct.
And so that's a dissolved corporation or entity, a dissolved LLC. So how does, I'm still trying to get to the point of, all right, so if I'm the PR of this estate, how am I maladministrating the estate vis-a-vis the interest of a now dissolved LLC, who was the beneficiary of the trust that owned these assets?
Because at the time that the LLC, well, really at the time of death, the LLC was in existence, and there's no operating agreement for that LLC. And so we go to the default rules under Florida Statute 605.0602, which states that if there is nothing else, there's nothing in the operating agreement which dictates what happens when a member passes, then those rules kick in, which essentially say that it would pass via whatever the will or the trust of the decedent says, or the intestacy statute.
But the
And so
decedent here didn't have a will, correct?
He did not. And so, therefore, at the time of death, his interest, the decedent's interest in AMA Investment Limited, Management, would have gone, since he had no spouse and no children, to the parents, and he had a 1/3 interest at the time in that corporation company.
So the statute you referenced, I believe it was raised by the appellee, states that those interests should have gone to the other brother and sister. Is that not correct?
I didn't hear your question.
So with AMA, there were 3 members, right? There were the 3 children,
Correct.
and then the decedent in this case died, so we're left with 2 children, correct?
Correct.
Okay, and then the argument by appellee is that, the trial court below, the trial court stated that the interest of the decedent in this case would go to those 2 individuals, to the other 2 brother and sister. Are you not in agreement with that?
I'm not in agreement with that. That's not the default. It's 6050602. Do the judges have any other questions in regard to that property or the JS Land Trust? I think another issue with the trial court with the land trust was that the trial court didn't differentiate, and this has been an issue, in these proceedings going earlier, even when I tried for my motion for partial summary judgment. But I don't think that there's an understanding between what a trust is under the trust code and a land trust, and I think that that's where a lot of the confusion arose. Of course, the court's order looks at 733-504, which is the removal statute, and the 3 subsections, which is subsection 4, subsection 5, and subsection 9, I believe, that we raised. The second one, subsection 5, being the wasting and maladministration, which we've been addressing, but there are more issues regarding the maladministration. This estate has not filed a tax return yet, an income tax return at all, even though this money's been sitting there since 2020. And the money has not been invested. Mr. Oda never inquired as to, from a financial advisor, some sort of conservative investment for the money, and the cases of...
Why doesn't your client just take her 1/2? I mean, there's X dollars that were distributed as the settlement. I know that the PR took $36,000 in some fashion preemptively here, but the judge basically said, okay, that comes out of his half. And that was not good, but that's not enough for me to want to remove the guy. Here, appellant, you take your half, you, Mr. PR, take your other half, your remaining net, and that would then your client could invest away, right?
I understand what you're saying, Judge Lambert, and thank you, but I think that the purpose of our rules and our laws is so that the citizens of the state can have confidence that they can resolve a dispute in our courts and get a fair result. And this case has been going on for over 3 years. And every time we got close to trial, the appellees would fire his counsel, or they would withdraw. I think they all withdrew, actually. They would withdraw, and then he would get new counsel, which would continue to make the case go longer and longer. At one point, the appellee even asked for a stay so he could go look for new counsel. And really, it's the appellee is trying to get an end run, I think, on justice, right? He's getting an end run by saying, I'm just going to drag this out long enough so that all these bad things that I did don't matter because there's only this left. And it's like, I was talking to the other attorney, it's like when there's a breach of contract case and the debtor says, well, I'm going to declare bankruptcy, or I don't have the money, so what's the point of you suing me? You know, contract law is not based on enforcement. Otherwise, it would take all the meaning out of privity of contract, right? What's the point? And it's the same thing here. We have these rules that govern a fiduciary in a position of trust, which just simply didn't happen.
But the statute says may. It's a discretionary call. It's the same rule. If you want to expand upon the rules, the judge has the discretion to say, I've listened to this. I hear what this case is about. Yeah, you might not have been the best PR I've ever seen, and you advance, but I can resolve that by simply saying, you know, you've already taken 36, give her her half, close the estate, goodbye, move on.
Correct, but a party to a lawsuit should be able to rely on presentations from another lawyer or from a fiduciary without having to dig into litigation like this. Appellee's first attorney represented several times that all the money is in the bank, nothing has been distributed, nothing is even anticipated to be distributed. Only upon rumors did my client start digging, and there are a lot of cases that really outline what is enough for a court, what is enough and what is not enough for a court to remove. And if you look at the trial, and this case, sorry, I keep cutting my own self off, but this case, I'm running out of time. This case actually is more egregious than a lot of the cases that I cited. And if you look at the court's order in paragraph 6 and 7, I think it's 7, I'm trying to find the court's reasoning here. A moment. Because you mentioned the 50%. And we never contested the 50%. I'm sorry, it's paragraph 14. The court states, the court finds, even though everyone admitted that he took the money, which was only discovered because I forced the issue of providing records, there was no inventory even for 2 years. The court finds that the personal representative's removal of $35,000 concurrent with tendering to the wife her portion of 50% does not rise to the level of wasting or maladministration because it will be denied. And she says somewhere else up here, but that was not the paragraph I was looking for, that he offered her 50% and she takes, oh here, I'm sorry, it's paragraph 10. She says, it doesn't rise to the level because The wife rejected the 50%, which is not true. It had never been contested, by letter dated July 28th, asking for 172. There's nothing in evidence. That letter is not in evidence. That email, whatever it was, it's not in evidence. There's nothing in evidence that reflects that she asked for more than 50%. And I'm over my time. Thank you.
Okay, thank you. Yeah.
Do you need to get something?
Yes, sorry. I didn't want to interrupt. Thank you.
Okay.
Good morning. May it please the court. My name is Kelly Johnson, and I represent the appellee, Maher O'Day, as personal representative of the estate of Adele O'Day. As the court is aware, the position that the appellee took in their answer brief was that this matter, that the court didn't have jurisdiction over the order in this case.
Why not?
Specifically because it did not finally resolve a right or an obligation of the party in this matter. While I understand that the rules of procedure list the removal or appointment or refusal to remove a fiduciary as one of those orders that could be appealed as a final order,
That's what's here, right?
that's what's before the court. I would argue that the order from the trial court is not a final order, and that is because
But it's an appealable order. I mean, it doesn't close the estate, but it's one of the numerous listed appealable orders in probate under 9.170B. I mean, and it was...
theoretically, yes.
Well, why is that theoretical? I mean, is it a fiduciary, isn't a PR as a fiduciary?
Yes, Your Honor.
Okay, so we agree with that number. I mean, they could
I
have...
agree with that, yes.
All right, so...
My argument is to the finality requirement.
But doesn't the rule itself said orders that finally determine a right or obligation include but are not limited to orders that remove or refuse to remove a fiduciary?
Correct.
I mean, the rule itself says it's a final, it's got some finality to it.
That those orders could have some finality to it. I would argue that the rules don't contemplate this type of scenario in which there's a probate case that only has one, possibly two assets. Nothing needs to be
What does
managed.
that have to do? What if there was 50 assets? How does that become dispositive vis-a-vis the language of the rule?
Well, I believe if there's a fiduciary duty to continue to manage assets of the estate, then the removal of that fiduciary would be pertinent and
But I
would be
mean, but their
appealable.
position is, okay, the guy took $36,000, $1,035, clearly had no authority to do that just outright. That's bad, that's maladministering the estate. Maybe the net effect, as the probate judge said, well, we'll just deduct that from your share. But I mean, it's still, that's not things that PR should be doing absent court permission, or unless the will actually said to do that, which we have none here.
Correct.
Then, all right, so that's a reason to say, I don't have a trust of this PR. I would like her or him removed, and they petition. They're unsuccessful, so it was an order that did not permit the removal of a fiduciary, and the rule written by the Supreme Court allows somebody to appeal that as a matter of course here, so we would have jurisdiction. Now, whether it's successful, I mean, that's, and then the last part of the rule says, and you could call up any other order that was entered that was not otherwise appealable, which would be the order denying the motion for summary judgment, just like in a regular, at the end of a civil trial. I mean, that's
Correct.
You could. I mean, I don't know that it much matters here because I think the summary judgment requests and the trial requests are the same. Remove your guy, so
Correct.
he either is going to be removed by us reversing or not, but it's still within our bailiwick, or using you know, Judge Boatwright's buddy Scalia, it's within our jurisdiction to do this, to address it, right? Now, does that become problematic vis-à-vis what you're talking about today, because all you talked about was jurisdiction?
No, I will respond to the appellate's argument orally to the court as far as,
Is that okay? In the sense that, they've made their argument, you've not responded substantively to their argument because you've wrote on the jurisdictional discussion, but so she doesn't have the benefit of saying, well, if you don't like my jurisdictional argument, panel, here's why I think she substantively doesn't win. That's not part of the, so, I don't know, he's the guy presiding, so.
No, I agree. I think you're limited to the arguments raised in your brief or questions that we ask.
Yeah, I mean, if we could, you might not like it, your opponent might not like it if we start diving into the substance of her argument and ask you to respond, because you've not responded to her in writing with an answer brief as to that issue.
as to that issue, yes.
So you have to wait to see if Judge Harris throws out the bait or something like that. So, for Judge Boatwright, I guess he's more the fisherman. I'm not the fisherman, so I have no bait to throw.
No, I have no specific questions. Is there anything further that's raised in your answer brief that you would like to argue this morning?
No, Your Honor.
Okay. All right, thank you. You do.
Well, just since this, so your rebuttal would be to respond to what your opposing counsel just said, who we've told we have jurisdiction.
I literally have a 5-second or 10-second.
Hey, your 10
statement.
seconds worth.
Thank you, Your Honor. I just wanted to remind and point out, which has been pointed out, that the appellee does not contest any of the substantive arguments or breaches that were alleged in the initial brief, and or any of the arguments as to the errors of the trial court. That's all. Thank you.
Yeah.
All right, thank you very much.
Yeah,
both
she
of
said
you.
we shouldn't even hear it at two jurisdictions, what her answer brief was. So, okay, thank you. There you go.
There you go.
There you